So good evening, everyone. My name is Tim Foley, and I'm the CEO and Executive Vice President of the Building and Realty Institute, which includes among its members the CCAC, the Cooperatives and Condominiums Advisory Council. Welcome to our information session tonight on the recent changes to the Westchester County laws governing co-op admissions. The way tonight's going to work is we're running this webinar style. We'll have some initial presentations which won't exceed more than 15 minutes, and then we will answer as many questions as possible from you as submitted in the Q&A box. So if you are familiar with Zoom, you know where to find the Zoom toolbar that you have logged in. There's specifically a Q&A box. You can go ahead and drop your question in there, and during the Q&A session, we'll try to answer as many of them as possible. There is also a chat box. When we get to Q&A, we will not be rigorously checking that chat box. We'll really be trying to answer your questions in Q&A, so that's where you should put it. If you're joining us by phone, or if we run out of time and we're not able to answer your question, you're always able to follow up with us at info@buildersinstitute.org. So a couple of other pieces of information. As you've just heard, this webinar is being recorded. Yesterday's information session was being recorded as well. We're going to take the best recording and put it up on YouTube so that you can share it with board members who are not able to attend either information session but still are interested in some of this information. So if you would like tonight's to be the one, then you better make the questions especially good, and that'll mean that we'll post it on YouTube. Number two, everyone who has registered for this event, whether you're attending or not, will receive follow-up information from us. That follow-up information is going to include at least one of the documents that's come out of Westchester County that you will need to start to use for applications beginning August 1st. We have the exact content of it, and we'll share that with all of you. It will include memos by tonight's presenter, Daniel Finger of Finger & Finger, a professional company, as well as the law firm of Himmelfarb and Scher, who is working with us on putting together our fair housing training so that you can meet the requirements of the law. You'll get both of those memos. And then the last thing that you'll get from us is a list of the protected classes. You're going to hear that phrase an awful lot. When it comes to housing discrimination takes place not just on any old criteria, but whether you belong to one of several protected classes as specified in federal, state, or Westchester County law. So knowing what those classes are is important. You cannot discriminate against anyone by virtue of them being a member of those classes, but certain other things, like for example financials, or how they behave themselves within the course of the interview, or whether they're a smoker or a non-smoker, is not a protected class. Finally, you're not going to hear a lot of commentary from us on the law itself tonight. Obviously, the BRI and the CCAC have an extensive track record over the past several months about exactly how we feel about it, but the goal of tonight is really just to get you up and running so you're ready to hit the ground running with this law when it takes effect beginning on August 1st. So without further ado, again, if you have questions as we go along, please feel free to drop them within the Q&A box. I'm going to share my screen and take you through a brief presentation on what is in this law. All right. Now, most of you are familiar that this law was passed by the Westchester County Legislature at the end of last month, and it was signed by County Executive George Latimer. And it builds on the law that had previously been passed governing the regulations of the co-op admission process in 2018. So with that in mind, it's worth reminding you what was in the 2018 bill. It was primarily a bill that was focused on timelines for evaluating applicants. Most of you are in compliance with this law. We heard during the run-up to the passage of the new law that there were only 5 violations issued for non-compliance with this 2018 set of provisions. You should be very familiar with them already. They are unchanged. You must notify the applicant whether the application is complete or has defects within 15 days. When the applicant submits a corrected application, you then must let them know if it is complete or has further defects that need to be solved, also within 15 days. And then within 60 days of them being notified that their application is complete, you must provide a written notice whether you approve or deny the application. And then after the applicant has received the notice, for example, saying that they've been denied the application, within 15 days notice of getting that denial notice, you must also send a copy of that denial notice to the Westchester County Human Rights Commission. That's exactly the law as it stands today, and the law that was most recently passed builds on top of this. Just one quick editorial note, we've been asking CCAC members as well as folks who are managing agents within our Advisory Council of Managing Agents at the BRI to, wherever possible, copy us on that letter that is going to the Westchester County Human Rights Commission. That's been very valuable to us. We've been able to sort of independently verify what has been going to them and what hasn't been going to them over the past few years. We would ask you to continue that practice if you're a CCAC or ACMA member. So now on to this new law that was passed last month and takes effect on August 1st. Here are the parts of it. Number one, each application must have a standard notice to the applicant explaining the laws against housing discrimination, how to file a complaint if you feel you have been discriminated against, and the timeline for review as specified in the 2018 law. And this is what that cover letter looks like. It must be part of your application beginning on August 1st. And as we said, we will send you this document. They even specify the exact text of it within the statute, and they also specify the font size. It has to be a minimum of 12 points. If there is other relevant information that you think is germane to include on this notice, you may add to it, but you should not deviate from the language that is specified in this notice. If you don't like the style or you think you can polish it up, you're advised not to do that. It is spelled out exactly what needs to be in the notice within the statute, and you can add to it, but you shouldn't try and edit it. So we'll send you that notice as mentioned after this session. Number two, quoting directly from the law here, the application to purchase shares of the corporation's stock must disclose any minimum financial qualifications that a prospective purchaser must meet to qualify to purchase the shares. Some cooperatives operating within Westchester County already have some type of minimum financial qualification statement that they include in their application packet, that they include on their website, or that they otherwise make known to the applicants. If you are one of those cooperatives that already has a set of minimum financial qualifications that you have published, then you essentially can keep doing what you're doing. This doesn't particularly affect you. But many housing cooperatives do not have a formal policy on minimum financial qualifications. In order to comply with this law beginning August 1st, you either should develop one or you should provide the second paragraph's worth of information. To the extent that a cooperative housing corporation does not have firm mandatory minimum financial qualifications, the application must disclose at a minimum the corporation's preferred minimum income, liquid asset total and credit score, and preferred maximum debt to income ratio and percentage of purchase price being financed. So what are those items again? It's the preferred minimum income, it is the preferred liquid asset total, the preferred credit score, the preferred maximum debt to income ratio, and the preferred percentage of purchase price being financed. Now, this does not mean that if someone matches these preferred minimums or a more stringent statement that you are already using as your policy, that they automatically get the shares in the corporation and the apartment unit that goes with it. There's any number of reasons, including financial, that go beyond what these minimum financial qualifications are. Nor is it necessarily saying that if you check off these boxes, you automatically are entitled to this, that, or the other thing. All it is saying is that you must disclose either what your financial requirements are or these preferred preferences to the applicant as part of your application. Number 3, the rejection letter. For the law in 2018, it was sort of freeform. It wasn't particularly spelled out what information needed to be in this letter. The Human Rights Commission has been tasked with developing a form letter which must contain the following information for all rejections beginning on August 1st. These include the name and address of the co-op, the address and the unit number being applied for, the contact information of the denied applicants and sellers, the contact information for all real estate brokers and attorneys involved to that point, the date of the receipt of the initial application, the date of the receipt of the completed application, the date of any interviews, the date of the rejection, and the reason for the rejection. As mentioned, Human Rights Commission is putting together a form letter, and of course it would be recommended that you adhere as closely to the form as possible. What does that form letter look like? We don't know. They were tasked with publicizing a form letter by Friday, the end of last week. They have not met that deadline. We have been informed that it has been drafted. It is awaiting various levels of bureaucratic approval within the county. As soon as they publish it, they will be looking to promulgate it far and wide. We will share that rejection letter format, whatever it is, the second that we get it by blasting it out through our email. Of course, we have all of your emails because you're here. And we also have the emails of the folks who were unable to attend this session who are already in our email database. We'll send it out to as many people as possible. Again, you only need to begin using this rejection letter when this law takes effect on August 1st. Number 4, all members of the Governing Board of Cooperative Housing Corporations are required to undergo fair housing training. All board members must have 2 hours of training every 2 years. Since this is the first year that this requirement is going into effect, they have a requirement for new board members. They must be trained within 60 days of taking office, and that will carry forward. But also there is a time period for existing board members to get trained. Existing board members must be trained within 9 months of the effective date, so essentially by May 1st. And then moving forward, it's 2 hours of training every 2 years. Now, as we mentioned many times in the run-up to this law being passed, as well as in the chat box tonight and in other emails that you've received by us, if you are a dues-paying member of the CCAC, the BRI is providing fair housing training on a monthly basis for as long as we need to get existing board members trained within the date range that's within the law and moving forward for new board members. And we will be providing that to dues-paying members free of charge. You must keep records of attendance and furnish them to the Human Rights Committee upon request. What that specifically means is if they're looking into this, that, or the other thing, they may well ask for your documentation that all of your board members have gone through this training. And if you are unable to provide the paperwork showing that they have, they would take that as on its face of it, a violation. So definitely record keeping will become important. Human Rights Commission was supposed to publish an outline of the minimum standards for training. That was also supposed to come out within 15 days of the effective date, so the deadline for that was last Friday. We do not have it yet. Human Rights Commission was also supposed to publish qualifications for who can give the training. What type of person would be qualified to give this fair housing training? We have also not yet seen the final qualifications. We have had conversations with the Human Rights Commission. We do generally know the topics that they will be requiring because they're written directly into the statute. I can say that all of the fair housing trainings that BRI has given over the past several years would cover those same topics. We're just waiting for additional information from them on what they would like to see in them. We've also had some direct communication with them that this published list of qualifications for who can give the training ought to include the same persons that we have always used for our fair housing training, which has generally been real estate attorneys like Mr. Finger, who you'll be hearing from shortly, as well as nonprofit organizations that specialize in this type of housing discrimination and fair housing cases, like Westchester Residential Opportunities. So anyone that we would normally use is the type of person that they're trying to put into this qualifications, but we'll have to wait and see what the final determination is. And then, of course, there are penalties. Noncompliance of any of the requirements set forth in this section shall be an independent violation. What does that mean? That means, let's say that there is a complaint raised against your co-op, Human Rights Commission investigates the complaint, and they find that not only did you miss the 15-day deadline that you were supposed to have, and not only was the rejection letter threadbare and it didn't have half of the information that you were supposed to have, but also it turns out one of your board members didn't do their fair housing training within the past 2 years. Each of those violations would carry with it its own fine. So now we're going to get into part 2. What doesn't the law say? And fundamentally, the biggest thing that it doesn't touch is what the grounds are for a co-op board to reject an applicant. We know from the statistics that rejections are relatively rare. From the statistics that we had looking at the approved sales that went forward in Westchester County and compared to the number of denials, about 90% of transactions are going through. And for the most part, the grounds that a co-op had to reject someone in the past are the grounds that they will continue have to rejecting people. That said, with all these different requirements, it's worth taking a look at what your practices are and making sure that they are as defensible as possible. So with that, I would like to turn it over to Daniel Finger for the second part of our presentation. Some of you have already dropped questions in Q&A. Please feel free to continue doing so while we listen to Daniel. Daniel, take it away.
Thank you, Tim. All right, so just to backtrack a little bit, I want to just review some of the things that haven't changed. You mentioned some of them already. Boards still have discretion to reject an applicant. We know that it's relatively rare, but you still have the ability to reject. It's not an automatic acceptance if they meet any requirements or anything like that. You still have the right to interview. You still go through the process, analyze the application, and if there's something you don't like, you can reject it. The only thing to keep in mind, and this is also something that hasn't changed, is you can't discriminate. So you can reject people, you just can't reject people for illegal discriminatory reasons. The only difference with rejections is that you have to give a reason now, and you have to put that reason in writing. Another thing that hasn't changed is that there already was the requirement that we give a copy of the rejection letter to the Westchester County Human Rights Commission. That hasn't changed. The only part of that has changed is the additional requirements that Tim alluded to and reviewed, and the form of the letter. So the letter is now going to have a more particular form, but there was already the requirement that the boards provide a copy of that rejection to the Human Rights Commission. Again, as I said, you still can't discriminate. It's always been the law that you can't discriminate for illegal reasons. The protected classes, we've gone through this a number of times at different presentations, but some of them are, as we all know or should know, race, color, religion, age, national origin, alienage or citizenship status, ethnicity, familial status, creed, gender, sexual orientation, marital status, disability, source of income, etc. So those are the main protected classes. These are listed in the law actually, and they also say or status as a victim of domestic violence, sexual abuse, or stalking. So those are some of the protected classes. You can't discriminate for those reasons. The time frames are the same as the 2018 law. Those already existed, the ones that Tim reviewed, and you have 15 days to review the application to determine if it's complete. In most cases, the boards are not themselves, I know there's some exceptions, but most cases, the boards are not themselves reviewing the applications to determine if they're complete. They usually have that being done by either their managing agent or their attorney. That's usually the person that is processing the applications to determine them if they're complete. Those people, the managing agents, the attorneys that are processing the applications, they're not doing the deep dive to see, the financial analysis and, going through the tax returns, going through the different documents to make that deep analysis. They're going through to make sure the documents are there, to make sure that you have your complete tax return, to make sure that you have your complete, W-2s, whatever the documents are that you normally require as part of your application. Usually it's the tax returns, W-2s, pay stubs, bank account statements, financial account statements, things like that, reference letters, the contract of sale, stuff related to the loan if they're getting one. Those are the typical things. And the application coordinator is generally making sure that the documents are there. The board, so once it's determined that it's complete and everything is there, then it usually gets shipped to the board. And that starts the 60-day clock that the board has to approve or deny the application. If it's not complete, they go back to the applicant. And when the applicant tells them that it's complete, that, when they resubmit, then they have another 15 days to review and make sure that it's in fact complete. 60 days to approve or deny it. That has to then go to if it's denied, then that copy of that goes to the Human Rights Commission. The main differences, as Tim mentioned, just to reiterate, are that you now have to give your reasons, and you have to put that in writing. You have to disclose the minimums, and you have to undergo the training. So those are the main differences between the new law and the old law. And I think now probably we'll just go through some of the questions that people have asked, and then we can keep going through some of the other ones we've gotten.
Absolutely. So we've got, did you want to go through some overview questions? Do you want me to go right to the Q&A?
I want to go right to the Q&A, or if there's something you want to ask me, you can pop them up either way.
Yeah, that's fine. All right, so we're going to go through these Q&A. Again, this is scheduled to be an hour-long session. Yesterday, we exceeded our time. We're going to try and squeeze in extra questions as best as we can, and we'll go as quickly as possible. Question number 1, will there be classes that boards can attend for specifics on how to determine qualifications?
Well, we are going to have the class. We are going to be presenting the training. If we are assuming that we're allowed, we are going to be presenting the fair housing training. I am sure that there will be components where we will discuss the qualifications. I don't know that we're going to have a class just on how to determine qualifications. What I've said in the past on that issue, it's a good question. I think it's something that each board has to talk to their attorney, their accountant, maybe some brokers in the area, and really get a sense of the market value, the market for their properties, and really maybe look at the past couple of applications and see for the people that were approved, what their, the qualifications were, what their average, credit score was, what their average debt to income ratio. I would say that you probably, I don't think it's necessary to change your qualifications because of this law. The law isn't saying, it's not making a judgment on whether or not, the qualifications that co-ops have are too harsh or not harsh enough. They're saying that they want people that whatever those qualifications are, they want them to disclose them. So if you as a co-op are satisfied with your qualifications, if you're happy with generally the applicants that you're approving, and what you think a good debt to income ratio is, and what a good loan to value ratio is, and how much money you want them to have in the bank, and what you want them to have in terms of their credit score and things like that, then there's not really any reason to necessarily change it just because there's a new law. But if you do need help determining it, or your preferred minimums, I think it's going to be a very case-by-case basis, depending on the co-op, depending on the area they're in. So it's something, like I said, you have to probably talk to your professionals to get help with that.
Right. The only thing that I would add is, as folks know, if you're CCAC members, we have general membership meetings every other month on topics that are of particular interest to co-op board members. If it turns out that this is an area that a number of co-ops wind up really struggling with, this could be fodder for a future program.